I'm Emma Allen. I'm a solicitor and director at Fisher Solicitors. I focus in dispute resolution and also employment law, so that can range anywhere from a shareholder dispute to boundary disputes to employment law issues. Quite a big variety of disputes. Well, the Employment Right Bill was introduced on the 10th of October last year. So what's happened from this new government is that they want to give employees more rights almost instantly to protect employees' position when they're employed with a company. Really important that employers are aware of the changes because this will affect their policies and procedures, and also with regards to probationary periods they may want to look at thinking about having a longer probationary when rights come in from day one for the employees. So it's important to have them policies and procedures in place before it's enacted into law. If employers fail to do anything about the changes, they'll be faced with potential unfair dismissal claims from their employees. So that could lead to a rise in employment tribunal claims brought against the company. A particular change that's important for employers is that when it comes into force, which is looking likely at the beginning of 2026, when employees get day one rights, i.e. you can't just dismiss without a valid reason, and if they don't have a probationary period where they can get rid of an employee who doesn't fit for the company, that's really important to a business because it will cost them a lot of money, i.e. via settlement agreement if they wanted to terminate the employment with the employee on an amicable basis. If they didn't go down that route and they haven't got the probationary and the employee from day one is able to bring a claim in the employment tribunal, we're looking at lots of costs to the business. So it's really important that they take that on board now and future-proof. That doesn't mean to say that employers can't plan this, i.e. have longer probationary periods, which is suggested that it's going to be capped up to a 9-month probation period. So that means that an employer can't just sack you for no reason. A 0-hour contract is where there's no set hours given to an employee. So what the bill is introducing for 0 hours contract is that there should be a 12-week period of how many hours should be supplied to the employee. Now, if the company changes them hours or cancels them hours, there's going to be compensation allowed to the employees who's on 0-hour contracts. But an employee still can opt in for 0 hours if they want to. Before, on a 0-hour contract, it could be you can have 10 hours a month working here. Now, if they're only been provided 1 hour a month, there should be some compensation for the other 9 hours that they've not received under the new bill. So flexible working is when an employee can request a right to change their working hours in essence. The reason why it's changing from the bill that's been put forward in October is that flexible rights requests can be made from day one. The difference what's happening with flexible working is that from an employer's perspective, there is now a threshold where you've got to show why you have not allowed a flexible working request. The requests are now more onerous on the employer for the reasonableness test. So for an employer's perspective with regards to reasonableness, one of the reasons for refusing a flexible working request is it doesn't fit in with the commercial business needs of the company. So, but I suspect from having this threshold now of having to prove the reasonableness of the decision that's been made, more information is going to be required to back up why the employers said no. So the government have set out a plan which is broken down into two categories. So we've got the public sector and then the private sector. Any public or private sector of over 250 employees need to provide a report to government, which are on different deadlines. The public sector need to provide their report by the 30th of March 25. The private sector need to provide their reports by the 4th of April 25, and within them reports they need to say what the gender pay gap is between male and females, and also what support they're going to provide for menopause. Once that information is provided, I suspect that government will look at that as part of the enactment under the Employment Rights Bill, which I think will come in 2026. I think it's really important for employers to really get their act together to understand what could potentially come into play in 2026. The biggest thing for employers is unfair dismissal from day one. I think a thorough overhaul needs to happen with employment contracts within businesses to ensure that probationary periods are extended to foresee that right coming in from day one. There also needs to be some considerable thought about flexible working rights from day one as well, as to how companies are going to deal with as and when them flexible requests come in to make it fair amongst all of employees. So the government are making these changes to ensure that employees have more protection. The reason for that is because some companies don't follow policies and procedures and do just sack people unfairly. So there's clearly a need for more protection for employees, but it's managing that balance to ensure that employers can reasonably dismiss a employee on reasonable grounds. But it's yet to be seen as to how that's going to work when the Employment Rights Bill comes into play. Employers can prepare for the changes by seeking employment advice, particularly in relation to policies, procedures and standard contracts of employment. So to learn more, there's plenty of blogs and information on our website, but if you wanted to contact one of our specialists, please head to our website. Our telephone number and contact details are on there.